Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we are continuing with the interpretation of statute, deeds and documents. Right? So in the immediate preceding lecture, right, we were going through the external aid of interpretation and we have covered almost all of them, right? And the last one that you had, that was about the judicial decision, right? I had given you a brief about that, but we will be discussing in detail about the topic today. And after that, as I had already told you, that I will discuss about the points that are provided in your study material, because you need to know those 6 points and you have to write it down if you're asked about the total or in entirety to write about the external aid of interpretation. Then you have to write examples, right? So when you have to write the examples, I want you to write the examples given directly in your study material. But when you get to explain certain things, right, then you go back to the references that I have made in the previous 2 lectures, because over there you have in detail about the context that you need to write in your examination. But if you have an entire question, right, then you have to give those 6 examples that have been provided for you in your study material, right? And after that we'll switch on to the interpretation of deeds and documents. If time permits, we'll take it up in the same class. Otherwise, we will hold another, that will be the last class for this entire chapter, right? And over there we'll be discussing about the interpretation of deeds and documents, right? And after that, if it is needed, I would also go through some of the questions in your practice manual. Okay? So, let us begin with the judicial decision, the judicial pronouncements that we had, where we had left in the previous class. So on your screen you have that when we talk about the judicial pronouncements, right, we basically make a reference to the enactment, right? And then we also make a reference to the decisions that have been taken either by the Indian courts or the foreign courts. So we have 2 kinds of decision, either the Indian decision or the foreign decision, right? So let's see in detail how do these things impact and why do we consider them to be an external aid to interpretation. So basically, when we say that we have to make a reference to the enactment, then we actually mean to say that you will have to give your preference to the internal aids first, right? Your enactment is your act, the statute that you have, right? So first and the foremost weightage that you will give, or the priority that you give, is directly to the statute that you are following. So you apply the rule of literal interpretation. If it fails, apply other rule and try to interpret the text itself, right? And if you are not able to get the true meaning out of the text, then that is the point when you take a resort to the internal aid of interpretation. And when all the internal aids also fail, you move on to the external aids of interpretation, right? So even when we talk about the judicial pronouncements, okay, we know the judicial pronouncements are the pronouncements given by the court, right? The legal decisions that have been taken. But understand one thing, that these legal decisions, these judicial pronouncements are absolutely irrelevant if the text of the statute is clear, if it is not ambiguous, if it does not require an interpretation at all, right? The plain grammatical meaning makes true sense. So in that case, you will not be applying any other rule, nor will you resort to any internal aid of interpretation, and neither will you go to any external aid of interpretation, right? So always keep this in mind. When we're talking about external or internal aid of interpretation, just remember that they will not always be applicable. They will be applicable only when it is needed. That means other resources that we have applied failed to achieve the target. So we take the resort to the internal aid and then to the external aid, right? Because even you know, then when we are studying law, right, when we have dealt with the Companies Act or the other acts as well, there have been places when we had to talk about certain examples, right? Like one of the famous cases that we have been dealing with in our law is the Foss versus Harbottle, right? FOSS versus Harbottle. So when we were discussing about that case, that is one of the most important case, right? Remember that if you do not remember any other case, then still you have to remember at least this case, because the entire chapter is based on this case. Right? So what we actually did when we were referring to that case is that we were seeking help from the external, that is the external aid of interpretation. To be specific, we were trying to deal with the judicial pronouncements then. Right? The wordings of the case, what was the conclusion of the case, what did the court decide, that is what formed actually the basis of the entire chapter. Right? So that is when we take resort to the external aid of interpretation, but it only occurs if your true language of the meaning is, or true meaning of the language is not being interpreted in its true sense, in its cognate sense, by using the rules of interpretation. Right? Then we move on and we make reference to, when we make reference to decisions, right, there are two kinds of decisions basically. One is the Indian decision and the other is the foreign decision. So whenever we actually need to refer to any decision for interpretation and we have a decision given by an Indian court, maybe the High Court or the Supreme Court, and it's a famous decision, then we pick it up and we say that it was a similar case in that case, right? It was a similar case as to R, and over there the court finally came up with this interpretation, right? And so since we also have a similar case like the one in which we have the reference, so we can also construe it to be on the same tangent, and we will interpret the entire statute on the basis of what the court did in that particular case that we are referring to, right? But what if you do not even have an Indian decision? That means there is a case that has come up, which has come up for the first time, and no other court in the country has ever dealt with such a situation, and so they did not interpret the statute regarding that. So you have nothing to refer, right? In that case, you go beyond your boundaries. So that is one position where you will have to step out and look for cases and look for the pronouncements and the decisions taken by the courts of some other country, right? But when we talk about some other country, right, is it on a random basis selection? That yeah, we can go to Pakistan, we can go to Bangladesh, we can go to US, we can go to Russia, we can go to any country, we can go to China and see, okay, what decision did your court take in this case? This, okay, we'll adapt it. No, we cannot do that, right? Because we are not sure which country has what kind of law, right? What is the jurisdictional structure of a country? So if we want to refer to any case in any foreign decision, right, then we'll first have to estimate and understand, right, the jurisdiction of that country, right? Or if we say then the same country following system of jurisprudence. Now jurisprudence may be a new term for most of you, right? You must have all heard about jurisdiction, but jurisprudence is something new, right? So yeah, even in my course curriculum when I was going through this chapter, right, that was the first time even I came across this word. Because being a CA, when you come out of your class 12, when you step into your CA profession, right, then in class 12 you will have never heard about this word, and then since you do not go to any other course, and since directly after class 12 you start your CPT and IPCC, so over there also you do not have any reference to this word jurisprudence, right? So the first time and the last time that you will come across this word in your subject is in the law and in this chapter, right? Now what do you basically mean by jurisprudence? So jurisprudence is the study of law, right? It is an art of interpreting the law. So you have heard the term jurist, right? So who are those jurists? Those jurists are basically the scholars of jurisprudence, right? So we'll have to see whether the foreign country also follows the same system of jurisprudence. That means they have the same system of interpretation of the statute, right? They have the same system that defines their law, same scholars in their law, right? If they are moving in the same direction, if they are on the same tangent, then we can also accept their decision. Why? Because the law that they have formed for interpreting the statute is similar to ours, right? Are you clear with it? And the second thing that we have to also consider is that the foreign decision has been given on the same law as ours. If these two conditions satisfy, it is only then that we can move out to consider the decision of any foreign country, right? Now, basically, out of the subject, general knowledge. If we ever have to refer to any case, or if we ever have to refer to anything, right? If you want to gain knowledge about anything, if you want to copy anything, if you want to refer to anything, generally we go to England, right? We follow that Britishers concept. Yeah, maybe you can say because they ruled our country for so long or anything, whatever be the reason, right? But if you see our parliamentary structure, our presidential rule, all these things, over here the prime minister is the prime power, right? The president does not have the power. Similarly in Great Britain, in England, the prime minister is the most powerful person, unlike USA where the president is, right? So we generally do not follow these concepts. Our law, our jurisdiction are very much similar to England, UK, right, rather than the USA. Even your IFRS, right, that has been adopted from UK. IFRS is from UK. US GAAP is from US, but we adopt IFRS, right? Our standards on auditing, standards on accounting, all these things, right, they are basically referred to the Britishers. You'll find a lot of things common. Our parliamentary structure, our jurisdiction, our judicial body, all these things, right, they almost run on the parallel ground. So even when we are making any reference to the foreign decisions, then the first country that you look for or you look forward to is England. If you have any case over there, you take a reference of that case, right, rather than going to US. Their system, their jurisdiction, their law, all these things are a little different than ours. We don't run on a parallel ground. We are not on the parallel tangent, right? So over there it becomes a task. Okay, so basically, do you understand that first of all we will make a reference to our statute, our enactment, and try to interpret it on the basis of the rules of interpretation, the literal interpretation, reasonable construction, agism generis, all these things, all these rules will apply. And if we are able to derive the meaning out of the statute itself, then that is the best part you can have. Otherwise, refer to the internal aids first and then to the external aid. And even in the external aid, if you do not have anything in the Indian decision, you go to the super external aid, that is the foreign decision. Please don't take it very seriously. Super external is no word over here, right? I'm just trying to bring you a connect that when we are talking about the foreign decision, we are actually going a step beyond the external aid as well, right? So I clear with it? Clear with the concept of the jurisdictional pronouncements, judicial pronouncements? I hope yes. So with this we come to an end of the entire concept of the external aid to interpretation, right, that we needed to know. So whenever you get a specific question on the reference to the act or judicial pronouncements or dictionary definition or change in technology, social condition, anything, then you know what you have to write. Exactly what we have studied in the previous two classes, right? But again, I'm reminding you, if you get a question and they talk to you or they ask you to write about the external aids of interpretation, do not use these words, right? Because in your study material, you will nowhere find jurisdictional pronouncements. They straight away talk about the foreign decisions. They're not concerned with Indian decision at all, right? So just for that specific question, I'll show you what are the specific headings that have been given in your practice manual, in your study material, right? And what are those? I'll explain it to you in 2 lines each and wind it up. And then we'll come to an end, or we'll draw a ending line on the external aid of interpretation, right? So next we have the external aid to interpretation of statute. This is as per your study material, just remember it, right? So first is the historical setting. Okay, we have a common point. Then we have consolidating statutes and previous laws. Okay, then we have the usage, earlier and later act and analogous act, right? On the previous slide I had shown you this topic, we have discussed upon this topic, but this topic is actually not covered in the books that I refer, right? If you refer to the real interpretation of statute, the base, right? If you refer to the bare context for that, or if you refer to the various authors, they don't talk about this specific point, right? Change in technology, change in the social condition, these are the points that pop up. right? That is why when I was talking about this point, I clubbed those points as well, because as per your study material over here, you do not have any point. They have given this point and just explained it in 2 lines, and that is over. But if you are asked about such concept in the examination, then 2 lines will not suffice. So for that, you have to refer to the actual bare acts, to the books of various authors, to the institute's material, to the supplementaries provided by the institute. There are a lot of materials that you actually have to refer, right? But I'm sure as a student it becomes really difficult to refer to the various materials, right? Why? Because you have 8 subjects. You already have 16 materials to refer. One, the author that you are following, the coachings that you have taken, and the other is a study material. 8 subjects into 2 each, 16. So even I don't expect you to go around hovering through books, flipping through books, and then studying each topic specifically from different books, right? That is what I'm here for. I'll do that task for you, and I'll try to bring out all the best contents from each of the authors. Right? Recently there was a student who asked me about the book that he could refer, right? But my dear friends, there is no single book that I have referred, right? I have prepared my notes, and those are based on various authors, your study material, the bare act, and everything, right? We also have the audit classes. If you go and watch the audit classes, right, you will not find those content in any book of any authors, right? Why? Because I have taken content from the book of authors as well. I won't deny the fact, right? But just to sum it up, to complete it, right, where they have stopped, I had to go beyond, because there are content, right? So I'm not trying to just go with the bare act or go with institute study material, right? Various authors, they have also applied their brain. They have brought in some knowledgeable source over there. They have given some good explanations on a lot of topics. So they have to be brought in together, consolidated, and then delivered it to you, so that you have the best available for you, right? So I'm making an effort towards that, and I hope you cooperate with that, right? So if there is something you do not understand, or something you know that, okay, this is something I need to refer back later, so please prepare notes for that along with the class. As it is, I'm not going very fast, right? It is easy for you to prepare notes at this speed. You have it on the slide, write it down in a piece of paper, and whatever I'm explaining, just put an arrow and write it down in short in your language, that yeah, this is the content, this is the content. You will not need to refer the books. And if you're making flowcharts and actually preparing your notes very well, your notes will be enough for your examinations. Open your notes, and for specific topics, go through your study material. That is it, right? So after the earlier and later act and analogous act, we have the dictionary definition and the use of foreign decisions, right? As I told you, they do not use the term judicial pronouncements. They use the use of foreign decisions. They're least concerned about the Indian decisions, right? Okay, so these are the 6 points. I'll explain them, each of them in brief, so that if you are writing about this, you can also write some content. So the first one is the historical setting that we have already seen, right? And that is exactly the same. And if you're writing about historical setting, you can pick up the points that I have already discussed, right? The parliamentary history, the historical facts, the statements of object and reason, and a lot of things. Okay. Then you have consolidating statutes and previous law. So if you generally refer to the preamble of any act, you know what preamble is? A more detailed form of the long title, right? In short, if you remember, right, if you try to connect what preamble is, the internal aid to interpretation, we have discussed it in detail. So the preamble of various acts, they say that this is an act to consolidate the other acts, whichever act, right? It is blah blah XYZ act. So it says this is an act to consolidate this. So whenever you have something like that, when it says that it is an act to consolidate certain statute, right, then you generally make a presumption that they have not altered those statutes, they have not altered those laws, they have only consolidated them. So if there is any point of interpretation that you need and you're not able to interpret it by applying the rules from that act, then you can refer to the act that it has consolidated, and whatever that part, that para, that term meant in that previous act will also be applicable in the new act that you are referring to, that you are trying to interpret, right? And the basic reason behind it is that you are just consolidating the act. We have not talked about amending the act, right? So we presume, that is the general presumption, that the concept of the previous acts will be carried forward, right? So that is all about this topic, consolidating statutes and previous law. Then you have the word usage. So when you hear about the term usage, right, what is the first thing that comes to your mind? The first thing that generally should come to your mind is the application. That okay, we have a statute in front of us and we are trying to interpret as to what would be the true meaning out of that statute, right? What would be the true interpretation? So before or even after applying the rules, if you're not able to understand it very well, then what do? Is that you refer to the previous acts performed on the basis of that statute, right? If it's a statute, somebody must have been following it. So what is the general accepted term, right? Or what is the generally accepted interpretation that is practiced in the market and that has been a common platform over the past some time? So in general, you refer to any case, any particular situation, then you always see that okay, this is the general parlance in which it has always been used. So if it has derived its meaning with the normal usage in the normal scenario, right, over the past some time, then even you will have to construe it in the same direction. That okay, people have understood it in this way, they have been acting on it on this way, and the courts have also taken decision on the same direction. So if you have seen the usage of the statute and if you are able to interpret the basic usage, then that interpretation would suffice for the text, right? And this is basically to be followed when you are not able to gain anything out of the text or the internal aid to interpretation, right? That is when we come down to the external aid of interpretation, and usage forms an important part there, right? Then we have a reference to the earlier and the later act and the analogous act. So again, this is the same thing that we had over there, which means that if there was an earlier act, right, and to support or explain that act, you have another act that has come up, then the new act or the latter act, you say, should be used to interpret the previous act, the earlier act, right? But that is to be done only if both the acts are on the same line and a part of the earlier act is ambiguous. The concept that we are trying to interpret, the statute, the specific topic that we are trying to interpret, if it is ambiguous, then we would refer to the act that has been framed to define or to bring forward the major content of the earlier act, right? Then we have the dictionary definition, and when we talk about the dictionary definition, we again go back to the 3 points. That okay, first of all, we had the statutory definition, right? What is the definition given about that particular topic in the definitional section of the statute? If you have something, you will always refer to that. But if you do not have anything such, then you move ahead to the judicial decisions, the decisions that have been taken by certain courts. Judicial decision is the decision taken by the court on the particular topic, right? But if you do not have a judicial decision as well, then as a last resort, you refer to the dictionary meaning, the meaning of the ordinary words in true parlance. What is it being construed as? In general, what do public take it as, right? And if it is a technical word, then for that you will have to refer to the dictionary of those technical words. That means if it is a technical word related to law, then you know that you have a separate dictionary for law, right? So you will have to refer to that dictionary instead of your general dictionary, right? So you understand the meaning of the dictionary definition now? And then last, you have the use of the foreign decision. It is exactly what we have just discussed in the beginning of the class. That if over there you have the same system of jurisprudence and the foreign decisions have been given in the same law, then you can use those decisions to support the interpretation of the statute in India, right? And the major country that we always refer to is England. Okay with that? So that is basically the content of the study material. Although when I went on to explain, right, I took up the points again that we had discussed in the lecture before this, but there were some new topics, that is the consolidating statute, the usage. This we did not cover, right? So over there I have given you a separate explanation on that, and I hope the 6 points are clear with you. Right? So the external aid to interpretation of statute as per your study material is the historical setting, the consolidating statutes and previous law, usage, earlier and later act and analogous act, dictionary definition, and use of foreign decision. Right? Now I hope this topic is clear with you, and with this also we come to an end of the entire topic of the external aid to interpretation. Right? Now the only thing that we are left with in this chapter is the rules of interpretation of deeds and documents. So far whatever we have done were all related to the interpretation of statute. We did not talk about the interpretation of deeds and documents. Right? But now we will start with the discussion of the deeds and documents as well. I mean the interpretation of the deeds and documents as well. But again, since we have some time constraint, we'll take it up in the next lecture, start it and complete it in the next lecture itself. Right? So that will most probably be your last lecture on this chapter. Right? And then we'll move on to some major chapters like your SCRA, your IRDA, your SEBI and all those things. Right? I have been receiving requests of doing those chapters, right, over a long time, but I picked up with winding up and interpretation of statute in between. Why? Because those were again important and those were on higher demand. But now those students who were waiting for your SEBI and SCRA, your demands will soon be met, and we are actually taking up that chapter after this. Right? So stay tuned for that. Stay tuned for the next lecture on the interpretation of statute as well. Right? So until then, this is Abhinay Gupta signing off. Thank you and bye-bye.